Okay, I think we're going to get started. This is the last panel between us and lunch. So this panel is called Competition Regulation and the Evolution of Internet Business Models. And so what I want to do in this panel is to focus on issues involving the internet and particularly broadband business models, regulation, and the intersection between the two. We have really a great panel. All their bios are in detail in the program, but I'll just briefly introduce them all. Kevin Leddy is the Executive Vice President for Corporate Strategy at Time Warner Cable. Bob Quinn is the Senior Vice President, Federal Regulatory and the Chief Privacy Officer at AT&T. Josh Wright is a Commissioner at the Federal Trade Commission. And Chris Yu is a Professor of Law, Communication, and Computer and Information Science and the Director of the Center for Technology, Innovation, and Competition at the University of Pennsylvania Law School. Let me start out with taking off from the theme of the conference of creative destruction. Is creative destruction taking place in the broadband marketplace, and if so, what form is it taking? And in particular, is it reflected in new technologies, business model experimentation, both, or something else? Kevin, you want to take a crack at that?
Sure. First of all, I should say, based on the last panel, from Laura's lips to God's ears. We'll come back to the taxes. But creative destruction. The cable industry is very familiar with creative destruction. It's a harsh term, but maybe soften it to reinvention. I think our entire history is based on reinvention. We reinvented television 50 years ago. We reinvented internet access 18 years ago. We extended phone into digital phone. We're now reinventing commercial services, security services, media sales. Our whole history is based on taking other businesses and reinventing them. We're therefore very sensitive to people reinventing what we do too. We're constantly watching what creative destruction is going to happen to our business. And I think there are some very interesting things happening that impact broadband policy and broadband economics, particularly the creative destruction of the video business and the voice business. If you look at the networks that we in AT&T built, they were built for another purpose. We built our network for video services, and the network paid itself back based on television services. Because the return on the network was positive just with video, we were able to layer broadband on at a relatively low price. Same for voice services. But as the video business becomes less profitable, as over-the-air or over-the-top services start to erode the margins and erode the customer base, the burden on the broadband business has to be greater. So as prices go down effectively for customers in video and voice, prices are going to have to rise in broadband. So the share of wallet, I think, shifts considerably toward broadband over time, and we need to figure out how the destruction of the old businesses affects the new businesses.
So along those lines, recently, some CEOs of some major cable companies have suggested that the future, this is, I think, just putting a little bit more on what you said, that the future of their industry is one in which broadband is the primary offering, and TV just becomes an on-demand product like an application, like any other application. Do you see that happening?
I think it takes a long time for that to happen, but clearly the margins are shrinking in video and voice, and so they become less important parts of the business, and broadband becomes the primary business.
So Christopher, you've just written a whole book on the internet. I mean, how do you see this, whatever you want to call it, creative destruction or disruption occurring, and what form is it taking?
I want to really spotlight one point that Josh Gann started to hint at, but to make a very clear distinction. In the literature, there's a complete difference between what we call creative destruction and disruptive innovation. Creative destruction is new technologies pushing forth what we can do. Disruptive innovation, classically, it's pioneered by Clayton Christensen, but it's also in the work of Kim Clark, the former dean of Harvard Business School, and Rebecca Henderson of MIT. This is not the leading edge. This is actually the lower tech, existing off-the-shelf technologies that are left, and there's the market niche being left open at the bottom, where the companies that are obsessed with high-tech speeds push it farther and farther up and get too far away from their customers. And in fact, what you can do is create an opportunity for people who are not on the cutting edge of technology to actually innovate. That's what's classically disruptive innovation. And so in fact, they say that incumbent companies, the conclusion that Christensen draws, are actually more vulnerable to disruptive innovation. That is, market niches that they ignore that get lifted off the bottom. They create an opportunity in the bottom. And so for companies who are trying to strategize, you actually have to be careful. So I'll give you one example. I mean, it's sort of slightly related, but it's one part of the debate that really bugs me. I see constantly in the debate, we need, Europe has set as a goal 100 megabit service with 50% subscription by 2020. Constantly setting 100 megabit services as a goal for the US and all these, Australia, Korea, Japan, we hear all these numbers. Right now, the adoption rate for 100 megabit service, where it is available in the US, is 0.25%. And I think that this is an example of where technophiles get obsessed with the leading edge and actually start pushing this farther and farther up in ways that we don't appreciate. Also, and part of this is people say DSL is dead. I've been hearing this for 10 years. We've wrung more bandwidth out of that little twisted pair. And actually, with IP slams, we're talking about the November 2012 announcement that Bob's company made is they're going to be able to deliver 45 megabits per second at 18 kilofoot. And that's an amazing world where all of a sudden we have an interesting possibility where smaller, lower grade technological innovations may actually support it. And by the way, I think the count for people who are buying 25 meg service where it's available now is 11.5%. So it seems like there's an interesting reconfiguration we have to take in terms of not just following the technological edge, but understanding what consumers really need, figuring out how we can meet them with existing technologies, because it's very expensive to build 100 megabit services. To step back one level. So I'm a policy guy. I'm not running a company. What does that mean? It means that I don't think we should actually presume any outcome technologically. When UVerse and Fios were deploying at the same time, one of my students asked me, isn't UVerse being incredibly short-sighted? And my reaction is, we'll find out. There's a wonderful article by Armin Alkian, which Josh is fond of citing, which talks about evolutionary competition. And what they're really talking about there is not just natural selection, but he says random mutation too. That if you actually have business people and you ask them, why are you doing this new direction? They will give you an answer that may or may not have anything to do with anything. The only thing to Alkian that was important is that we have enough random new attempts at new business models to allow the market to determine what will survive and what won't survive. And to me, what I would like to see is, to me, the flip side of the UVerse story is that Verizon didn't do as well, perhaps, as they wanted on the Fios. They took a leap on LTE, and that has turned out very, very well. And so these are examples to me where we've allowed different companies to experiment with radically different business models without having a regulatory regime that presumed any particular outcome. And I think that we really need to think about that because we can't always see where these innovations are coming from. Sometimes they'll be raising the technological edge, and sometimes it'll be existing technologies that are recombined in ways that we don't fully understand.
Kevin talked about developing, having to get more revenue out of broadband. And this is something that was alluded to briefly in Bob Crandall's talk earlier, which is basically pricing issues. And I mean, so the pricing of broadband has been pretty much, at least in this country, flat rate, all you can eat pricing of broadband, and for a variety of reasons. But so there's a couple of you know, when it's talking about innovation in terms of business models, there's a couple of interesting questions. One is obviously usage-based or tiered pricing. That's a way to get more revenue. There's a fairly good argument, although obviously there are some arguments on the other side. It's not necessarily the case, but there's a fairly good argument that can also be good for consumers, especially consumers that have a lower ability to pay. So let me start out with that and then get to some other pricing issues. And then, so I mean, is usage-based or some sort of tiered pricing? Let me ask Bob and then Kevin. Is that likely to take off more and become much more widespread? Or?
Well, on the mobile side of the house, usage-based pricing is pretty much the rule today. You know, when we introduced the iPhone, it was introduced with an unlimited pricing model, and the scarcity of bandwidth quickly drove us into a model that was usage-based at its core. And I think the proliferation of the number of different mobile devices that consumers have kind of moved us into a world where that's changed a little bit. And what we're seeing now, especially on the wireless side, is accounts buying buckets of minutes because they have you know, just a multitude of different devices that they're going to hook up to the network or on Wi-Fi. They're going to use both of those strategies, but they have a multitude of devices. It's no longer, you know, one device per customer, one device per household. I mean, a lot of people in this room, I'm sure, they're working on iPads, they're working on computers that are connected to the internet. They have phones in their pocket that are connected to the internet. And it's kind of changed the way that we've approached it, but it's still at its core, it's a usage-based pricing model. And I think, to echo one of the things that Kevin said, when we entered into the sharing, if you will, of bandwidth on an account basis, one of the things that we did in that pricing structure is we gave unlimited voice and unlimited text messaging, because the revenue is just going out of that business. So they go into you know, an unlimited usage category, right. and eventually, you know, there's going to be no revenue left in those businesses. Right. It'll take time, but that's really where we see the market going. So on the wireless side, unlimited has been the rule for quite some time. It really almost since right after the introduction of the original iPhone in 2007. On the wireline side, you know, the thing that drove usage-based pricing on the wireless side was really the need to get the bits off of the wireless infrastructure and onto the wireline infrastructure as quickly as we possibly could. You don't face that dilemma as much on the wireline side, but it's not to say that there isn't usage-based pricing. Even in our UVerse footprint, we have caps that are set relatively high in the UVerse part of the network, which is completely IP-based. I think they're 250 gigs a month. In the legacy DSL part, where I think it's a little more constrained, they're down at about 150 gigabits a month. But that model hasn't taken off as much on the wireline side, mainly because there wasn't that scarcity of bandwidth, particularly with the spectrum issues that we have, driving it as much on the wireline side. So
let me do, before we go on, let me add another, not to go away from the usage-based pricing, but let me add another element that may happen. I mean, it was brought up, I guess, in the wireless context, the suggestion that ESPN might pay wireless carriers so that ESPN content doesn't count against their cap. But that just really raises the general question, which is, you know, whether applications and content providers start paying ISPs for access in some form or for quality of access. I mean, actually, I'd like to hear everybody comment on this. I'd like to hear Josh comment on these things from an economic point of view. But Chris, you had your...
Well, before I get on that, I want to issue a challenge to the industry, actually, about usage-based pricing simpliciter, which is, I think it's being implemented in a very bad way by the industry, and it's angering our consumers, which is, If a person uses a tiny amount of bandwidth at the peak time, they're having a huge impact on the network that's not being measured by bandwidth caps or total usage. If a person uses tons of volume when the network's slack, they're not having any impact. It's about peak. The wireless cell phone pricing reflects that. Night and evening minutes back to telephone days reflects that. And right now, we all know that, in fact, monthly bandwidth caps are a terrible way to actually meter the impact on the industry. And it seems like a relatively natural way to actually encourage people to do things better is to create a more sensible version of the bandwidth caps and the way that we do usage, time-sensitive based. Now, usage-based pricing. Now, there are problems. There's a limited number of cognitively that consumers will accept. They'll only accept a certain number of times a day. And that, in fact, this becomes hard to do. The other problem is machine-to-machine, because that violates, it can do it at different times. But actually, machine-to-machine stuff tends not to be latency sensitive. If the machines are smart enough, they can rearrange the times in ways that you avoid congesting the network when it's congested. But I have a plea to the industry. I think that we could help consumers, all of your customers, and take a lot of political pressure off of this and solving the problems that people have if we could find a more intelligent way to do usage-based pricing.
So from the industry folks, is there any impediment, or what is the impediment?
Well, I'm just going to say this is like Back to the Future, right? Because I came out of the long distance industry, where if you called at 11 o'clock at night, it was one rate. If you called between the hours of 8 and 5, it was another. If you called at 7, it was another. And if it was at 2 o'clock in the morning, it was another. And all I ever heard from everyone, policymakers and everyone, is too complicated. It's absolutely too complicated. And so, I mean, to me, this is like Back to the Future. I mean, we had all that in the long distance area. And at the end of the day, I don't think consumers they're just not, the bulk of consumers are not savvy enough to understand or have the time to invest to understand all of those issues. So I was smiling when you were saying it, because I feel like that model was completely rejected in the long distance calling sphere.
I also think it's fair, Chris. We should show you the data. You're right. The cost of the network is determined at peak. And there's this theoretical possibility that your very heavy consumers are not heavy consumers at peak, and therefore charging for total consumption is unfair because they're not putting a burden on at peak. But in fact, heavy consumers are heavy consumers at peak. Mm-hmm. The flows are almost identical. So even though it seems a little crude, charging for total consumption actually is a proxy for charging for consumption at peak.
I understand there's a problem. There is clear literature that says consumers will only accept so many gradations. The bulk of the problem is between 7 and 11 o'clock at night. Is there a way that we can actually do this? Can we provide an incentive to change the needle that Kevin's talking about, where we actually can change the behavior of the heavy users so that they actually reduce their behavior at that time?
I mean, I think the evidence suggests a lot of consumers are not crazy about peak load pricing and electricity, where it's further along. So,
well, what's fascinating to me is that's an even bigger problem that the telecom industry has, because you have to match load and production at this 24/7, and so there's facilities, there are no drop packets on an electric power, and so there's things that only operate 2 days out of a year and have to recover their entire fixed cost of production in those 2 days. And then they're doing very, very aggressively trying to attempt to find ways to do this with limited success, admittedly.
But let me get back to my question, which was charging the other side of the platform, applications and content providers. Presumably, obviously, that'll lead us right into the open internet order. But what do you guys think about that? Is that going to happen? Is that a major source of revenue? Is that?
Well, I think it's something we ought to be able to experiment with. If you look at most transportation systems or communication systems, there's always a sender pays option, but there isn't on the internet today. Mm-hmm. It seems to violate the net neutrality rules somehow. So can ESPN even come to us and offer to pay for those bits, or is somebody going to complain that they're getting an unfair advantage by doing so? The rules are really fuzzy there, so we're not sure what we can do. But it makes sense to us that sender pays should apply to the internet.
So, you know, when my CEO has gone out and talked about this, he's talked about it from the wireless side, because I think there are less questions on the wireless side than there is on the wireline side, given how the open internet order was structured. And the pricing mechanism, as I said before, on the wireless side, in terms of usage-based pricing, it's really the predominant pricing structure that exists today. And I think ultimately there's going to be a demand for that, particularly as we get into some of the more high bandwidth intensive applications like video. And if somebody like ESPN, you know, breaks the model and says, you know, that's a way that we want to go in order to encourage consumers to buy and use our product, I think it'll happen. When it's happened, and when my boss went out and talked about it, or John Donovan, the head of our network, has gone out and talked about it, there usually follows 2 or 3 days of stories. And I'm sure Harold's sitting back there, so I know I'm going to hear about this tomorrow. Talking exactly that.
Probably earlier than tomorrow.
Yeah, probably earlier tomorrow. Earlier than tomorrow. But that's exactly what we'll have. Is we'll now have a discussion, because we've broached the topic as to whether or not that violates the open internet order.
Speaking of Harold, let me ask Josh a question. So we talk about these pricing mechanisms, which are you know, pricing the other side of the platform, you know, departing from flat rate pricing, and they're controversial in this industry, at least partly because of the open internet order. But the ultimate test, really, I mean, you come from an agency and from a way of thinking about these things, which looks at the impact on consumers. What do you think What do you think of the impact on consumers of these, if these types of things were more widely adopted, these types of pricing and business models?
A couple of things. First, I've never been on a panel when I was beat to citing Armin Alchian. And I'm still reeling over that.
He really butted in and he raised his hand.
So congratulations on that, Christopher. Second, I have to do this thing where I go in public now and I say, anything I say you can't hold against the commission or any other commissioner. It's close to that, but don't have it written down. I'm speaking for myself. Now, I do work at an agency who in the competition mission has consumer welfare as a mandate, and I'm an antitrust guy and an antitrust economist, and think of these issues from a consumer welfare sort of nature by training. It is always interesting for me to sort of with that hat come into debates in this industry where there's a different legal infrastructure and a different mindset about some of these things. Now, the vertical arrangements, and probably everything I'm going to say will hold with respect to experimenting with pricing as well as with vertical arrangements, like the ESPN example that you raised. But let me talk about the latter, because I think that's where you're going next. With respect to vertical arrangement, these are incredibly common across a number of industries, and something that the antitrust laws and antitrust agencies have had experience with for over a century. And over that century, the evolution of the legal treatment of those rules and the mode of analysis has developed a great deal, from the 60s through the revolution in economics, pointing out circumstances that have to hold for those arrangements to be problematic during the 80s and 90s, to a rule of reason approach in antitrust law that exists today. My own view is that that approach works fairly well, that what we've learned on the antitrust sort of side of the world from looking at vertical arrangements across a whole broad scope of industries is that they are generally pro-competitive, that they are in the sense that they improve consumer welfare, that sometimes they are not, and that we have a set of economic tools that meshes up pretty well with the legal tools on the antitrust side to identify the exceptional cases, and a set of remedies available to deal with that when we identify those cases. So I don't have any horse in the race with respect to whether this deal or that deal or the other deal is pro-competitive or anti-competitive, because that's not the way that we do the analysis in antitrust. We don't sit and say that group of deals is bad, rarely, maybe cartels, and nobody thinks this is that. So we analyze the facts on the ground, and encourage experimentation, and learn from it. With respect to whether or not I think these sorts of deals will be good for consumers, I think if one takes the vertical economics literature seriously and you had to bet money on it, you'd bet yes, right? But you'd bet yes knowing that you had a backstop of a set of rules that if you were wrong would allow you on a case-by-case basis to pluck off anti-competitive instances.
So, on a related issue, I mean, has the fact that the open internet order has is out there but also has not been resolved, has that, or other forms of regulation, has that kind of inhibited experimentation with new business models on the part of the industry? Or is that just an obvious question and doesn't even need it?
Well, I don't know that it's necessarily inhibited experimentation. I certainly on the wireline side, I think the rules are such that you always have to take into account exactly, how whatever you're thinking about fits into the structure of those rules. But in general, what we've always done is we came at the world from a history of common carriage, which really was designed to say, I'll sell my services to anybody. And I'm not interested in, saying, hey, I want to sell my services to you, but I want to deny them to your competitor. So, we supported the open internet order when it happened because we really didn't have to change the way that we did business in order to make the accommodation to the FCC order. And I think we would have supported legislation at the time as long as it was done in a way that would allow us to create new business models and offer them that were pro-consumer and offer them, on a non-competitive basis. So I would say that at this point, I wouldn't say that it has inhibited it, but it has certainly impacted it because we have to view everything from the prism of those rules. And as I point out to you, I think it's pretty clear. Harold will argue with me, but I think it's pretty clear that
that's why we have
800 service. Yeah, no, that's all right. Harold and I agree on some stuff. We disagree on others. But I think the 800 services that we talked about in the ESPN, I think it's very clear that that's a service that would be totally consistent with the wireless rules that exist at the commission. But every time we talk about it, we have a little public debate about whether or not that's right. So I wouldn't say that it has no impact, but I don't think inhibit is the right word, but we do have to put everything in context now.
So, well, let me just go one step forward and ask this to Kevin. Let's assume that the order is struck down. How do you think that'll affect the way you do business and the development of the broadband business platform?
I don't think it'll change things very much. I think we might experiment a little bit more. But there aren't big initiatives that we're holding back on because of the open internet order. There is definitely some confusion, though, about new business relationships. For example, if a lot of the content aggregators today are trying to essentially bypass the transit providers and the colo facilities and locate their servers directly in our network. It's not clear from the open internet order whether that's overly favorable treatment of those companies or not. And the sender pays issue is another one that's a little bit vague, although I guess if you're coming from the wireless world, it feels safer. So I think we would prefer to have certainty here, but there's not some set of initiatives waiting for that certainty.
Do you care certainty, which way the certainty goes? I mean, either it's upheld or it's not, or it's struck down, or are you indifferent between those two?
I think I should hold on that one.
Okay. Well, let me move again to Josh. Josh, you have suggested, I guess, if the open internet order is struck down, that the FTC is there to fill the vacuum, and moreover that the FTC is for a variety of reasons better equipped to address the types of questions that the open internet order was designed to address. You want to expand on that a little bit?
Sure. So this was a position that I held and argued vigorously for as an academic, and I don't intend on running from it now. And I also think it's still right. So a couple of things. I have said that I believe that if the FTC is placed in a position where it is given responsibility for regulatory oversight over these types of arrangements, that it is well suited to do so. I have no opinion on, I don't bet on DC Circuit cases now. But if it goes out a particular way,
Intrade is now out of business.
Right. It's harder. All of that said, so a couple of reasons why I think that the FTC is particularly well suited to do this. One, and I hinted at some of this in my last answer, this is that there is conduct in the world for which you want categorical prohibitions. We have some of them in that you would want a categorical prohibition from an antitrust perspective. Conduct that you know is always bad. Right? You don't want to take and drain the administrative resources and figure out on a case-by-case basis because economic learning has taught you, or judicial learning or common sense or what have you, have taught you collectively that the conduct at issue is always bad and should be treated as such. We have that in antitrust with, for example, naked price fixing arrangements, more or less not much else. But that is in part a response to the economic learning that has occurred over a variety of types of business conduct over the last century and in some cases much longer. With respect to the analytical box within which these types of business arrangements, those discussed under the net neutrality order, would fall, there is, I think, a fairly robust framework within the competition sphere, pretty widespread agreement on what types of inputs we would need to figure out whether the arrangements would likely be anti-competitive or pro-competitive. Maybe some disagreements on the margins between economists or lawyers on a case-by-case basis, but the analytical framework, I think, is fairly well agreed upon, established in the courts. It's what the agencies do. It's what the FTC does every day when we look at vertical cases. And for that reason, I think we've got a set of tools that are particularly well suited for avoiding a situation that would deprive consumers the benefits of the pro-competitive arrangements that the literature and common sense and so forth say are out there, while still having enough in its toolbox to both to successfully identify while avoiding false positives and remedies to correct when we identify on a case-by-case basis, as happens. The agencies bring vertical cases and they win them. To identify those cases and do the right thing when they come across. So from my view, and I think from an economic perspective, I don't think, and I've said this elsewhere, I don't think it's a particularly close question that the rule of reason analysis is a much better framework, whether housed in the FTC has the tools to do it, we've done it for longer, than other alternatives I've seen discussed in this debate. I think that's right, and I suspect that the FTC staff and its lawyers and the commission as a whole would do its job if the job were given to us.
Anybody else want to comment on that? Or?
Well, as a part of the open internet orders really got multiple components to it, but it's important to remember that one of the things that the FCC did when they did the order was they issued a transparency requirement. So as a result of that, every ISP today has a section of their website that's devoted to their network management practices, where people disclose exactly how it is that they comply with the order. And it's foreseeable that even if the DC Circuit would say you can't regulate, that a rule on transparency is under the jurisdiction that was cited by the FCC is entirely reasonable, and that's a reasonable form of, if you will, Title I type jurisdiction under the FCC's format. I think given that, I think it opens up the world to the Federal Trade Commission to step in. If the ability to do transparency is upheld by the FCC may have the ability to come in and say, hey, you've got to tell people how you're managing your network, and if you deviate from how you say you're managing your network, we have the ability to come in and say, for competition purposes, you've got to do what you say, what service you're selling, you got to sell that service and you got to perform that way. I don't think, even if the DC Circuit reverses here, I don't think that's going to change. And I think that there's many of the companies that supported that order, and there were an enormous amount of ISPs that supported that order. I think you're going to have a framework that's going to be enforceable and may be enforceable both the FCC and the FTC, even if the underlying rules were attacked.
I've said this before and I'll say it again. The thing that comes after the open internet decision will be more open internet, no matter how it comes out. If it gets struck down, we'll have a question about Title II jurisdiction. We'll have a question about FTC jurisdiction. There's some states that may try to get involved, and they'll be pushing legislation for a clean. This is what Gigi Sohn's been asking for, a simple bill. If it's upheld, there's still going to be all the details. I think Kevin and Bob have been very gracious. I do think that it's hurting innovation by companies. The best example I can think of is when Kevin's company announced bandwidth caps, usage-based pricing, something the order specifically recognizes as okay. Certain members of the advocacy community complained about it vigorously as a violation of network neutrality, and they actually backed off. And it's a problem. It's an overhanging uncertainty, even if it's just a publicity aspect, makes it very difficult to work in this space. Now, there's a whole literature on two-sided markets that actually say that, in fact, the ESPN-type pricing arrangements are extremely beneficial. Peering makes sense when costs are symmetric and revenues are symmetric. We all know that terminating last mile to residences is much more expensive, and we know that the revenue model is actually advertising-driven primarily, where you have revenue flowing into one side. And what the literature will tell you is these prices should be all over the place, and the best model to me is broadcast television. Networks paid their last mile distributors, those were television stations, years to be part of their affiliate, not because they were being generous, because they made back the money in advertising and then some. It was good business for them to do it, and that was a good thing that helped. And then what happened was the pricing started getting strange, where it would vary different with different affiliates. And in fact, sometimes it would even, if an affiliate was so weak, they would tell them, you have to pay us to stay part of the network. So the direction, the magnitude should be all over the place if we're going to have an open world. Clearly, in the NPRM, this type of pricing arrangement is something that the FCC, the way they framed out the open internet order, is objectionable. It's the one kind of price you can't charge is for a last mile provider to charge a content provider for money. And from a purely economic sense, there's no real justification for limiting across that type of pricing, because it suggests that that's a very natural and helpful thing to happen under certain circumstances.
Let me ask one final question before we go to the audience. Just kind of it's actually a fairly big question, but hopefully we can dispense with it quickly. I mean, obviously, at least part of this industry has a history of, a common carrier history. So, I mean, the basic question, what's the basic question? What type of regulation is warranted in an IP-only world and in the new world of telecommunication? Is there any regulation that's warranted? Any ex-ante regulation?
Do you want to answer that?
Absolutely not.
I did this. This is for you, Bob.
I know you were looking at me, but I thought I'd duck because I was interested in hearing what the commissioner had to say. I believe that the FCC and policymakers in general have a monumental task ahead of ourselves. And I think the history of Title II regulation in this country, that was established formally in the Communications Act of 1934 has really kind of turned on its head. Prior to, the advent of broadband, the service that was regulated by the FCC was a monopoly wireline voice service. And we put requirements on that. And by the way, the network was synonymous with the service. The network and the service were the same thing, and we put the regulation on the service, and we had a goal to get voice service to every part of this country, and we made some universal service decisions, policy decisions that were designed to encourage that. What IP does in the world, as far as I can tell, one of the most fundamental things it does is you no longer need a network to provide the service. That was never the case in the old circuit switched world, period. You had to have the network to provide the service. By separating the network from the delivery of the service, it's put the regulators and policymakers in kind of a fundamental position. Every time we have a debate about regulation, it usually comes down to it's a desire to use the competitive models of the 1990s to say we need to regulate the broadband infrastructure, and it's not about the service that rides over that infrastructure anymore. And I think fundamentally we have to have a discussion in this country about what are the characteristics in the future of the service that we're going to regulate. Is it real-time communications? It's probably not just voice anymore, but is it real-time communications? And then we have to decide, because 911 and public safety plays a huge role in this, what are the requirements? Because that's the first thing that you're going to come into. And then you're going to have make some decisions about consumer protection rules that apply to it. But you have to make the fundamental choice, in my view, at the outset, as to what the characteristics of this service that replaced monopoly wireline voice service that we grew up with for the last 100 years, what are the characteristics of that service, and then be very judicious about the requirements that you're going to put on that service on a going forward basis. And I'll give you a perfect example. We just went through this at the FCC on text to 911. And the FCC adopted a definition on interconnected text providers. And so what they've done is they've told the world, if you have a closed proprietary model, we're not going to have any regulation on it. But if you have a text service that can communicate to everyone, then we're going to impose some kind of requirement. We don't know what it is yet because we're going to move in the future. And the over-the-top guys are not happy about that. And I totally understand that they're not happy about it. And what it's going to drive them to do is it's going to drive them to create communication services that are closed in nature, which can't be the right public policy goal at the end of the day. And I think we really have to, that's the hardest thing that we're going to have to tackle because it's the biggest fundamental change, and which is really deciding what the service is before we start figuring out what are the minimal requirements that we're going to put on those services on a going forward nature, understanding that because you don't need this huge capital investment to create a network to provide the service, you're going to have a lot more choices than you ever had in 1934 or 1960.
Let me throw it open to the audience. Harold?
Y'all could have me on these panels instead of the Spectrum panels.
I think Joan would like that.
But I did have to, there were just a couple of things I would, I guess, ask about. Particularly, I think, with regard to Chris and the question of differentiated pricing models, which I happen to agree with you. It would be nice to see more variation. I've said I like the way Time Warner Cable has been trying to do this, of having a basic price and then discounting. The question I would ask, I guess, is sort of twofold. One, what is the purpose of the price differentiation here? If you look at the literature, there are a couple of different ones, and people have said a couple of different ones. It's everything from congestion management pricing to price differentiation to encourage adoption. There are a bunch of different potential models, but I think that so the question I would ask, I guess, is one is, do there seem to be, some things, because, how you price and what price differentiation makes sense depends on what you're trying to accomplish. The other, though, is I would just put out there that we seem to have much more pricing variability the greater the level of competition we have in the marketplace. We see the cell phone market, where we have four-firm national competition, has very differentiated pricing. As we kind of drop down various levels to where there's more competition, we see much less differentiation. Is there a problem if, for whatever reason, there is not sufficient competition in the market either to discover the best pricing models or because there simply is not incentive to pass on the efficiencies to consumers?
Do you want to take the first one?
Sure.
I think the point of usage-based pricing is revenue maximization for capital maximization, capital spending maximization. It's a very fundamental economic model change that needs to take place. Today, the consumption by different customers is vastly different. Within our standard tier of service, which sells for about $45 and is 15 megabits per second, if you do a quintile analysis, the top quintile uses over 100 times as much per month as the bottom quintile. But we're raising prices for all customers equally these days because that's sort of the accepted model in the marketplace. But what that's doing is it's driving the low-end customers out of the market. Now, where would they go? They'd either go to wireless or they disconnect altogether and do their internet work at their place of employment, whatever. What we don't want to have happen is for the low end of the market to get disaffected and not contribute revenue to the whole business. So we need differentiated pricing, not just on speed, but also on consumption. I think there's that fairness issue, but there is the revenue maximization issue too. I also think we need it to align incentives between us and the content aggregators. Today, there's this tension where they want to push more and more content to our customers, understandably, and the way they're doing that is either in more hours of consumption or in a higher data rate for the video that they're streaming. And we have a natural resistance to them flooding our networks with that incremental traffic. If we have usage-based pricing, then we're aligned with those content aggregators. And the final reason, I think, for moving to it is that we get better incentives to be efficient on the network. Today, if you're a content aggregator and you're not paying for sending your traffic to customers, you have little incentive to reduce your data rate to maximize the codecs that you're using to transmit your video. And video, of course, is the issue. But if there's some resistance by customers or some acknowledgement by customers of how much they're consuming, then there should be pressure back on the senders to be as efficient as possible in what they're sending. So I think just generally usage-based pricing aligns the economics much better with all parties involved and is ultimately better for consumers because we invest more money in the network.
So is usage-based pricing, the way you've described, at least the second half of that, charging more to the heavier users, is that roughly equivalent to charging the senders?
Could be. It could be. We haven't modeled that out yet. I don't know how much the senders would be willing to contribute or whether they're allowed to figure that out themselves. I mean, the other issue is could some of the senders get prioritization over other traffic? At this point, traffic management is, well, it's on the wireless world. There is some form of traffic management, but there isn't in the wireline world. So senders be willing to pay differently for different prioritization?
Well, Tom, you were nice enough to mention my book. One of the points I try to make is that we should see more complex pricing and, frankly, services, because what consumers want from the network is now more heterogeneous, and the networks have to provide more services that are in response. And people tend to think about speed and bandwidth, but actually they'll tell you there's things like latency and jitter, and that in fact the ways you enhance different aspects trade off against others, and that what we should expect to see a much richer variety. Part of it is, to answer the last question directly, part of it is about quelling the heavy users, but the part of it that's always been controversial, and I'll say the words Ramsey pricing, which will be familiar to everyone here, is value-based pricing based on what the sender is sending and how much value they place on it. That's been well established in the economic literature. It's been very controversial in the regulatory literature. And we're in a world right now actually where people who are providing services through the network are using big data analytics to actually do this in the extreme and to extract a lot of the surplus. But at this point, the internal parts of the market, the network, are not allowed to do that. And is generally not accepted, well accepted. One of the things I've mentioned to some of you is that I've been in the process of expanding our law and technology program at Penn. One of the conferences we're planning to do is to try to understand Harold's question, which is, what are the problems with this? Why is there this reflexive, historical, going back to the railroad days, resistance to value-based pricing? Why do people not like the fact that if you search for an airfare on an Apple device, there is evidence that you may get a higher price than if you search on a non-Apple device? And is there we need to understand, an economist has one answer for that, but I think that there's more to that question than that. The last thing I'll say about this, though, is the one thing I hope that we will understand is that common carriage probably isn't the answer. Bob Crandall in his initial talk mentioned both Susan Crawford and Tim Wu. They are actually pushing that as an answer. And going back to the future, we forget, there's a whole literature that talk about how common carriage really wasn't working that well. I have a paper I'll be presenting at TPRC. It says, is there a place for common carriage in an internet-based world? And I review all the literature about how it facilitates collusion, it overcapitalizes things, creates systematic incentives. And a lot of things that are fallen out of the debate that I actually think need to be reintroduced because the tools we need to manage that were never worked that well. There are a lot of other problems like care last resort, which are hanging out there that we need to work out a little bit differently. But it's pretty clear to me Back to the Future probably isn't the answer.
Link?
Tom, you've asked some great questions as a moderator, but it kind of led us into policy almost exclusively and not talking much about the whole topic, which is creative destruction and growth, which to me the elements are largely competition and innovation. And I'm just wondering what the panelists think about the broadband sector as part of what I call the internet ecosystem, the other companies that are part of this space too. How does competition work in this space now? I think it's a lot more dynamic than it used to be, that there's actually a lot of cross-sector competition now, that things that internet companies do or over-the-top companies do does affect the broadband providers and vice versa. And if that's true, that has a big impact on policy, but I haven't heard that discussed much today.
I think, Link, you've hit the nail on the head. The way I tell my students is, you have people who deliver products and people make them. Hey, unless you're maximizing the number of shoes you sell, the manufacturer and the retailer aren't maximizing their value. And that is a cooperative aspect, which ought to dominate because it's iterated over time. There are times that the adversarial components where the claiming behavior in one round dominate, and they shouldn't. And that, in fact, another point I make in the book is that we are moving from a world of, in some parts of the business, what I think of as extensive competition, that is, you build out more and more and bring new people in, and intensive competition, which is delivering higher value to people who are in the market. And I believe that in certain parts of this business, the shift to intensive competition really forces the entire ecosystem to think cooperatively, how are we going to maximize the value? And I see from talking with my friends in this room and other places, a greater openness to think creatively about not just worrying about your own business, but understanding that your business depends on cooperating with other people's, and it's not just the providers. There's hardware manufacturers and content, the whole gamut have to come together in a way that before it becomes a pocketbook issue and it gets in the headlines and people are blogging about it, there's a time where we can think about where the real sources of value are and how we maximize them, and that it has to be done, I think, with a lot of trust in a form that actually can bring that out.
Baron?
So Kevin, you were describing the various things that go into your calculation here about maximizing revenue and experimenting with pricing structure. I'm curious to get back to the point that Josh was raising about the role for antitrust law and how it may shape this sort of pricing model. If you could elaborate on how it informs your own thinking about pricing, and just to illustrate one example, and I wouldn't suggest this is necessarily the right one because I think it's really up to companies to innovate in their pricing structures, but I could certainly imagine that if the concern about data tiers is that it somehow discriminates against other sources of video delivery or backup solutions or other forms of high bandwidth usage, and if your concern is that you both price access fairly so that you can maximize revenues, but also deal with Chris's point about network congestion, I could imagine one potential outlet being, to harken back to the structure of long-distance calling, that usage might be unmetered during certain hours of the night, where congestion isn't a problem, but that would allow many services to innovate around running their backup systems in the middle of the night. Or, for example, my Roku box could simply stream the Netflix content that I want in the middle of the night and then serve that to the devices on my home network whenever I want them. So again, that's just an example, but I'm curious to hear how you and others think about antitrust concerns preemptively shaping the way that you innovate in pricing structure.
Well, you're absolutely right. As soon as we start to move toward usage-based pricing, we immediately get accused of discrimination. It's odd logic. We get accused of discriminating against applications that use a lot more capacity than applications that don't use very much capacity. But the point is, we're not going to be able to escape the discrimination charge. We're in the video business. We've always been in the video business. Video is what's driving traffic on the internet today. Therefore, if we put any caps in place, it's going to look to some like we're trying to stifle competition in the video space. So we need to rely on the antitrust laws. The antitrust laws, we've got 100 years of experience with antitrust laws that are designed to protect other companies and consumers against that kind of discrimination. And we just need to hope that they play out and show that, in fact, ISPs are not discriminating. We're just trying to maximize the economics of the network.
If there's one last question, we could probably accommodate it. If not, we can adjourn for lunch, which is, oh, did you, yeah, okay.
Hi, Dan O'Connor from CCIA. Just kind of changing a slight separate topic here, having to do with internet competition, kind of going up a layer. A lot of talk about net neutrality and the open internet order. I was kind of curious to hear Commissioner Wright speak to some of the work that the FTC has done recently on advocating against public restraints on trade. And the Uber examples are what come to mind. But I know that's been a kind of key area that has been a lot of local competitive issues around, and the FTC seems to really have stepped into that. And maybe if Professor, you can talk about that too, but I was really curious about what Commissioner Wright had to say about the FTC's work in that area.
Sure. Look, I think this is some of the Commission's, I think, highest rate of return work is what comes out of the advocacy shop. Is traditionally, if you sort of look back over time, focused on, if you look at the subject matter the advocacy work is focused on, it's generally been focused on pretty blatantly anti-competitive state regulations, lobbied for by incumbents to keep out new entrants. So from, dental hygienists in North Carolina to, you've got also nurse practitioner restrictions and so forth. As of late, the focus has been on, and this is under the leadership of Andy Gavel, who's running the policy shop at the Commission, who I think is doing fantastic work, focused on attempts, I think that could be fairly characterized as sort of living in a more high-tech space, Uber being one. The Commission has done advocacy in a couple of individual regions, DC being one, Colorado being another with respect to Uber. But I think, and I think this is a wonderful thing, that the Uber example is part of a broader trend by the policy office to get more involved in attempts to prohibit experimentation and new entry by new business models in particular across a variety of industries that are in high-tech spaces, including the Uber example, but not limited to that. And I think you can expect to see more of that. And for my money, I think we do a lot of hard cases. These vertical cases I mentioned are hard. They're hard because there are pro-competitive reasons to adopt the contracts, and they also can be anti-competitive. The way that you get to the bottom of what's going on is not by counting the number of firms, which is a pretty bad predictor of economic performance, but it's by going to the empirical evidence, grappling with the theory, grappling with the documents. These are hard, intensive cases. We get them wrong sometimes. I built a career off of pointing out when we did as an academic. But we get them right too. But the point being, they're hard. This stuff is not hard in the sense of knowing that it's generating positive rates of return for consumers. So I think these are important efforts for us to continue, and I think you should expect to see more of it.
But in answer to your question to me, it's easy to figure out that it'd be good for consumers. It's hard to remedy it because there's a problem called Parker versus Brown, where you have to essentially accuse them of doing a sham. And so it's not just Uber, and if you were at the Congressional Internet Conference, the head of Uber was talking about all the dirty tricks they're playing. It's amazing. And people who provide networks, rights of way, this is traditional stuff. You have to have a way to accuse, not just understand that it would help consumers, but to find a way to get around Parker versus Brown to say that the local regulator is doing something anti-competitive deliberately that has always been an enormous obstacle to implementing the remedies in this. And it's hard to do.
Yeah. Phoebe Putney, the Supreme Court decision helps with this. Doesn't get all the way there. But I think when Tim Uris was the chairman of the agency, they had a state action task force, had a big sort of nice report, and brought a ton of cases trying to move the law in this area to make it weaken the Parker immunity. They had some successes. One, much later came in the North Carolina board case that just came down recently. I think that those efforts, including the advocacy stuff, but also litigating to impact the doctrine, are things that that's a more expensive investment, but I think one that's worth doing. There is no shortage of the Uber-like examples out there.
Okay, let's give the panel a hand. Thank them. It was a great discussion. Lunch will be, I think, outside in the courtyard, and that'll be followed by, and we'll hear a speech from Chairwoman Ramirez, and that'll be followed by the breakout sessions beginning at 2.